Hello and welcome to Data Matters. Incredibly, we have actually come to the end of the series of going through the 12 domains under GDPR, but never fear, it's not the end of the show. Joining my business partner, Steve Wright, this week. Hi, Steve.
Hi.
I'm delighted that we have Sana Narman. Sana is Data Protection Lead at Harvey Nichols. Hi, Sana.
Hey.
We also have Phil Lee. Phil is a partner at Field Fisher. Hi there, Phil. Thank you.
Hi, everyone. Glad to be here.
Joining us. So Sana and Phil are going to help us understand what is actually meant by records of processing and why getting this right is such a crucial part of your defensible position under the GDPR. So there's a lot to cover here. It's a fairly complex topic. So I'm going to begin and dig right in and start with Phil. So Phil, can you help us understand the specific legal requirements? What does RoPA actually mean? What are the key legal requirements under the GDPR, please?
Sure. So RoPA is really just a shorthand way of referring to records of processing activities. And it's a requirement that exists under Article 30 of the GDPR. And to kind of understand why it exists, it's kind of helpful just to step back for a second and understand how it came about. Because before the GDPR came into effect, under the old data protection law, there was a requirement that if you were a data controller, you had to register your data processing activities with each of the different data protection authorities that you were subject to. And it was seen as a big exercise in red tape. And one of the things that the GDPR aimed to do was to remove unnecessary red tape. And so rather than having this situation where before you began processing, you were required to go and register with individual data protection authorities, the GDPR puts a little bit more trust on organizations and requires them instead to be accountable. And part of doing that is instead to maintain internal records of the data processing that you undertake. So rather than registering that externally, you now maintain those records internally. And Article 30 basically says that there's certain types of information you have to keep within your records about who you are and what types of data you're collecting and why you're processing it and who you're sharing that data with. And you maintain those records, and then if at a future date a regulator wants to inspect you and see what you're up to, you can hand over those records as evidence of the processing that you do.
Thanks, Phil. That was really, really clear and well explained. I expect though, Sana, that a lot of organisations might have had some problems fulfilling these obligations. Can you talk to us about that?
Sure, of course. So I think, as Phil said, kind of the whole introduction with the official Article 30 RoPA in the GDPR, I think made some organisations kind of panic in some way, like that there's this legal requirement now. This is something that some organisations might have had previously, but this is like kind of a legal requirement now. We've got to get on top of this. And I think sort of for each business, it also made them think about kind of how to do this, because there isn't a kind of uniform way of doing a sort of set rope. I think it's very personal for each business, I think, which can be quite, obviously if you're a complicated business, if you're a smaller business, I think each business had to think about how they were going to implement this and introduce this. And I think for some companies, it was really taking a step back and thinking about doing sort of data mapping exercises to really get an idea of kind of the life cycle of their data, and then looking at things that kind of fall into place afterwards, leading all the way to accountability. So I think for some organisations, it really was a first step, I think, with the introduction of the GDPR. But for others, I think it was just kind of trying to make some sort of order of what they might have already had in place. So I think it's just such a spectrum, really, of how each organisation might have approached it.
Sure, yeah, absolutely, Sana. And Phil, has the introduction of GDPR made a difference to the level of risk of the business is facing in this area as well?
No, I mean, unquestionably. Quite aside from sort of Article 30 requirements specifically, I mean, when you look at the introduction of the GDPR, there was a massive increase in the geographic scope of European data protection laws. So you didn't just have to be an organisation in the EU, but you could be outside of the EU and collecting data about European citizens. And suddenly you were subject to this new law. It will also increase the scope of the law because it applied to data processors directly as well as data controllers, and both controllers and processors are required to maintain their Article 30 records. And it also increased, if you like, the auditability of compliance as well, because one of the big changes under the GDPR was this idea that you made organizations much more accountable for what they were doing, whether that's by virtue of creating Article 30 records, or by creating data protection impact assessments, or appointing a DPO, or reporting data security breaches. All of those things basically, if you're a lawyer like me, serve as a roadmap for regulators to enforce against you. Any kind of shortcomings in the documentation that you're required to maintain will be evidence that you're not living up to your GDPR commitment. So yes, very much I would say it does increase risk.
Yeah, that sounds really comprehensive, Phil. And Sana, I imagine in some cases, as you sort of touched on earlier, that there have been some implementation challenges. Can you sort of talk to us about some that you might have witnessed?
Absolutely. So I think sort of an example that always comes up in my mind is from the very outset, where you might be doing some questionnaires, you might have sent to kind of different business functions. And I think it's just trying to kind of get everybody in the organisation on the same page to actually really understand the importance of having a RoPA, and actually that it's got to be up to date. And I think just sort of like, something that comes to mind really is when I was working with an ex-colleague on kind of the very first stages of some data mapping, and we were sat with members of kind of different business functions and asking them questions such as, do you instruct any third parties? And the answer was no, we don't really work with any third parties in this area of the business. And then as you go later on through other questions, you might ask something about where are your servers, or who are your servers with? Oh yeah, that's with X company. So it's just kind of, really getting people from, the business to really understand and come to grasp actually with some of the terms used in this process. As Phil said, you've got controllers, you've got processes. I think, really getting people in the business to understand what all of these terms mean, touching on training and awareness. And it's it's a simple thing really if you think about it, but quite complicated in implementing that in a business.
Yes, absolutely, and yeah, I can imagine there were some, or there have been and still are, difficulties in doing so, and I imagine that as a result we might have seen a few enforcement cases around this. Steve, perhaps you can talk to us about any that you've seen.
Yeah, thanks, Vic. I totally agree with the points that Sana and Phil were making. I think the whole idea and concept of the RoPA, it reminds me of what was called the Statement of Applicability for the ISO 27001 Information Security Management System, which I helped implement one of the first data centers and for PwC across their entire business. And in the Statement of Applicability, it was kind of like this RoPA concept, where you can link through to various different documentations that actually support the commitment to your risk-based attitude, if you like, to a whole range of controls that have been specified under the ISO standard. And I think this is not too dissimilar, in as much as the way I think about the RoPA is, and I'll come to your point, I'll answer your question in a sec, is if you think about it, what you're looking for is the sort of, not just a privacy policy or a, an interview with say a board member about their commitment towards privacy and trust. What you actually want to know is that the organisation is organised and that they've got the correct lawful basis fully understood for the processing activities that they're going to take. And so in terms of enforcement cases, you'll find very few actual regulators around Europe that have gone in specifically on Article 30. However, what you will find, along with Article 32, along the security incidents and breaches, which is the first reason why they're potentially coming in to investigate, Articles 5, 6, 7, around the lawful basis or insufficient legal definitions and bases for processing that data is quite quite a lot of enforcement cases. I've got cases where just recently, last week, the Norwegian fined an organisation. You've got the Spanish, the Belgium, and the Romanian governments, or sorry, regulators, all enforcing under those articles 6, 7 around insufficient lawful basis. Now, the way that they're going to enforce that is they're going to look at the RoPA. They're going to say, well, hang on a minute. You say you're doing this, but actually you're doing this, and this. So it stands to reason that if you want to be in a position as an organisation to have a good defence, should the regulators come knocking, or should a complaint be upheld and the subsequent investigation, that you want to have a fairly robust and comprehensive RoPA. And the only other thing I'll just say, Vic, is I'm still surprised at the amount of organisations that I work with and support that still haven't fully completed their RoPAs, and notwithstanding the fact that that is possibly, it sounds easy, we're talking about it here this afternoon, but it's really hard, because you've got to know the who, what, why, where, when of your data sets. And you've got to then articulate what the lawful basis is for each of those uses. So it's not an easy feat by any stretch of the imagination. But I am surprised. Here we are, 2 years after the regulation went live. We're finding an awful lot of cases, and the regulators around Europe, not so much in the ICO, but certainly in the rest of mainland Europe, are finding a lot of insufficient lawful basis, which points back to the RoPA Article 30.
Absolutely. I wonder if it's because people are grappling still with the other areas, but I'm sure we'll get into that later. Phil, I think you've probably got something to add here, I'm sure.
Yeah, absolutely. I was really just going to, I guess, follow up on some of Steve's points, which were that I think enforcement on Article 30 specifically is a sort of more or less unheard of now. Not entirely unheard of, because actually prior to this call, I did actually send an email around all my partners at work and working in our privacy practice to see if anybody was aware of any enforcement. And there have been a couple of cases in Belgium where the Belgian DPA has sort of slapped a couple of organisations over the wrist for not maintaining accurate records. But I think there's a couple of things to sort of bear in mind around this, one of which being that actually we are still very much in the early days of GDPR enforcement, and actually enforcement actions take a very long time. I've acted on a number since the GDPR has come into effect, and a lot of these investigations take upwards of a year to complete. So just because we haven't seen any yet doesn't mean that there aren't any in the pipeline. The other thing I would say, though, is that to Steve's point, I don't think regulators go in specifically to enforce companies about their non-compliance with Article 30, primarily because until a regulator gets in and looks at what you're doing behind the scenes, they won't know. It's not something like your privacy policy or your marketing statements or things like that are externally visible and can be easily checked as to whether you're in compliance. But, and again, I'm speaking from experience, I will tell you that when a regulator does investigate you, one of the very first things they ask to see is your Article 30 records. And if you don't have that, you typically look very stupid. And increasingly as well, a lot of the regulators will give you a very short period of time to respond. So there's one instance where I was acting on where the regulator came to one of our clients and asked for a copy of their Article 30 records along with a bunch of other documentation. And they wanted that information to be provided within 14 days. Now, if you haven't already got your Article 30 record ready, trying to do the data map and create those records in that space of time is a nigh on impossible feat. So, it's better to be prepared.
Oh, thanks, Phil. And I always have to bring it back to individual rights. I mean, is there a direct correlation between RoPA and an organisation knowing what's the legal basis for processing their data and the hopefully positive impact on rights here?
So, I mean, this is a really sort of interesting question, because actually, interestingly, when you look at the Article 30 requirements themselves, they don't actually require you to specify within your records of processing what your legal basis of processing are. So it's not strictly speaking a legal requirement, although in the UK, under UK data protection law, we do have that as a requirement if you're collecting sensitive personal data. So again, you get a little bit of diversity around the EU, but one of the things that I've sort of really noticed is that there is the kind of the baseline requirements that are set out in Article 30, which kind of we as lawyers tend to stick very religiously to and advise our clients not to put more in an Article 30 record than is absolutely strictly required. And then there tends to be more the kind of the compliance side of the house, where the Article 30 record becomes a tool not just about legal defensiveness, but also about understanding, actually how it is they're using data and whether or not they have a legal basis and whether or not they have conducted a data protection impact assessment for some of the processing they do. And so it becomes something wider and more functional than just an Article 30 record in the pure sense of what the GDPR expressly requires. And partly because of that, one of the things we've certainly seen some clients do is almost maintain two versions of their Article 30 record. One which is more of an internal document which includes everything they need to know about data and how they're managing it, and then one which is a more sort of pared back, bare bones, regulator friendly version of their Article 30 record that strictly complies with the requirements of the GDPR, but doesn't disclose more to regulators than they absolutely have to if they're asked to produce it.
Thanks, Phil. That's really interesting. I hadn't actually heard that before. And Sana, generally is. Oh, sorry. I think Steve's put his hand down. Chip in there.
No, I was just going to build on the point that Phil was saying. I think it's an excellent point, Phil, about the two. I don't want to say two-tier, but essentially you got your external facing and your internal facing, and I think that's really wise counsel, because there is aspects of some of that data and depending on how you've gone about compiling your RoPA, and a lot of organizations, especially technology companies that I'm working with, big data companies, are taking it from a pure data attributes level, and there's some really quite complex asset inventories, and then building upon that. So you almost do need an extrapolation, if you like, a regulator friendly version, which might be at a higher level, which then just sort of talks about the activities, because one client has over 230 different applications, and they're certainly not going to write for each of those, because most of them are legitimate interest and or contract for fulfillment requirements. So there is a kind of two-tier approach that I just wanted to pick up on. I thought it was a really good point, Phil. Thank you.
Yeah, absolutely. And I'd like to sort of bring Sana into that conversation as well, and just to think about, we're considering what consumers, what customers actually think about a company. So is this a good or a bad thing? Does this actually help organisations present the best face to their consumers?
Sure. I mean, it's interesting, obviously, the point that Phil made, because I certainly think with the compliance hat on there, about how, we can have, an inventory that kind of has everything in it that you need. And, it's a sort of a really good port of call, really, every time you need to understand what's happening in and around the business with data protection. I think the RoPA forms a really, really good basis for a number of things. Talking about lawful basis, for example, it's interesting because sometimes, I'm often speaking to people around the business, and they'll sometimes forget that we actually have an external facing privacy notice. And, sometimes they're so caught up with things that we have on, our data protection internal platform, and they'll be having a look on there. But actually, I think what's really interesting is within the RoPA, an all-inclusive RoPA, if you like, you can have information on there about your lawful basis. And I sometimes feel that within the business, you've got people who might want to kind of chop and change. On our privacy notice, it might say consent, but actually we're relying on legitimate interest here. And I think, that's where there's a lot of misunderstanding about how and what you can do. You can't just keep chopping and changing between what lawful basis you want to rely on. I think there needs to be consistency. And I think a RoPA is a really good platform, really, a basis to have all of that information on. And it also tells you actually where you've got the missing gaps. So I often use a RoPA as a basis to tell me, right, okay, if we've got, if we're relying on legitimate interest, for example, for a type of processing, have we done an assessment for that? Have we got an LIA to rely on? Have we got a DPIA for certain areas of the business? And coming back, Vicky, to your point on individual rights, if we've got some automated decision making going on in the business, what do you rely on to tell you that you've got this happening? I think, a RoPA can really be that basis, that foundation that you rely on. And also with coming back to kind of data mapping, the early stages of when you're compiling a RoPA, seeing the journey from where the data is coming in, where it's going throughout your business, and where it might be going out is a really good base to see, coming back to individual rights like erasure, access requests, where are those pockets of data held? What's going on with that? So I think, again, it forms a really good basis for individual rights.
Excellent, thanks, Sana. Steve, I think you had something to chip in.
Yeah, sorry. I feel like I'm spoiling the party because I'm really enjoying listening to Sana and Phil, but it keeps prompting lots of memories. And one of the questions that came through, which is something that's sort of, in my experience, I found often, and I won't name certain clients and organizations because they would hunt me down, but I was surprised at the lack of understanding about what a RoPA was in even privacy teams, and found that, and what I specifically mean by that, and it addresses one of the questions that's come through, about detailing the purpose of processing, not the description of what you're doing. If you're collecting I don't know, recruitment information or CVs and that thing, it's about what the purpose of that is. So how are you going to fulfill that? Well, we're collecting this information for the purpose of finding them a job. I'm paraphrasing there, obviously, but my point was just around the lack of understanding around the difference between a description and a purpose of, and finding the correct lawful basis by which you're processing. That's what we're trying to tease out here, as well as retention and other kind of who's got access and security, Article 32, etc. We're trying to tease out the real lawful basis. This is going to formulate, as Phil quite rightly said, it's going to be something you're going to show the regulator. So you need to be pretty darn clear that you're not just collecting data because you need to for your business. It's got to be the right lawful basis. That was the point I wanted to make.
Yeah, absolutely. I think that was a really, really well made point, actually, Steve, and probably one that some people have missed. We've got a lot of questions, understandably and unsurprisingly today. So I think what we'll do is we'll try to sort of pop through and answer as many of those as possible, and then to come back to round off with some practical tips on what good looks like. I know that Sana and Phil have already started to do that. So let's begin. The first question is, how could RoPA that has been created for GDPR be reused for LGPD? So Phil, do you want to
I'm so very glad that question came my way.
Yeah,
I think
you've got a Brazilian practice.
I mean, quite simply, I think the answer is that you're going to have a look at what the LGPD actually requires in terms of record keeping requirements. I'm afraid off the top of my head, I don't know, but I don't see any reason why the kind of document, the kind of structure that you're creating for GDPR couldn't be used as a more sort of general sort of record of your processing activities throughout the organization as a whole. And then, a lot of privacy regimes, wherever you go in the world, will always be interested in knowing certain types of information, who you're collecting data from, why you're collecting that information, who you're sharing it with, how long you retain it for, how you keep it secure. Those kinds of questions will always be common. And so I think you can always start with with something like that as your basis for creating a record for Brazilian compliance, and then just have a look at the LGPD and see whether there are any specificities that it has that go above and beyond those kind of baseline requirements that you might also want to include. So start from there and see what else is required, and speak to Brazilian counsel for a better answer, I think.
Excellent, thanks, Phil. Just as I was going through there, I think we've answered a couple of them, but let's pick out another one. So this question, we've yet to implement our RoPA due to time and resource. Is the panel aware of any templates which could be used or could be sent to services? So this is a public authority to complete. Or is there no substitute for sitting with the teams and questioning them directly? So, Sana or Steve? Sana, great.
I can make a start and Steve can add to it. I mean, the first thing that popped to mind is the ICO template. I think it's a fantastic baseline, I think, for any organisations that need something to rely on. I think it's like in an Excel format. So I think most organisations that are kind of starting from scratch tend to kind of have some sort of base, whether it's an Excel or some sort of, kind of baseline information inventory there that they can then build on and take into other platforms and do some really quirky, interesting things with. But yeah, the ICO do have a fantastic template to rely on.
Excellent, thanks, Sana. This one's for you, Steve. Do you feel processors are aware and diligent enough in understanding what they process on behalf of their customers? This person cited the NTT breach of 600 business customers.
So I'm going to give a diplomatic answer and say it depends, because I think definitely, it should be understood for on both sides. You can't. This goes back to the age-old problem of you're trying to outsource a risk, or you're trying to find a partner that you can outsource because your organization isn't necessarily a specialist in that particular area, right? So the challenge is, when it comes to data, if you're offshoring it or outsourcing it, then you still need to understand the lawful basis by which you're going to be processing it, and whether you're the controller or the processor, that needs to be very, very clear. And in particular, I would say the responsibilities between the controller and processor, and obviously if it's joint controller, that there are different scenarios which you can use. But in all of those scenarios, it's so important, and I'm just going to touch on a little bit of the previous question as well that Sana nicely put, around completion of the Excel nightmare. Sorry, did I say nightmare? The Excel RoPA that's kindly provided by the ICO, and there are other regulators that also offer that, so CNIL, because there is no real substitute for understanding the data flows, then better, if I give the example of John Lewis, where we thought there was only 6 data entry points into their systems, that it ended up being 21. That was determined by, yes, okay, process, we did discovery, but actually it was through interviews, by saying, well, how are you capturing that data? And then lo and behold, there's a whole new system and process that we've just, hadn't known about. So I think there's a level of analysis done, and the template is sufficient. It's quite detailed. The only other thing I would like to add, and I know Phil wants to come in on this one, is around you can spend so much time documenting everything. It's a bit like the Forth Road Bridge. By the time you come to it documenting, you've got to go back to the beginning, because the processes constantly change and evolve. So I would say, personally, a bit of a light touch, get those understanding about the lawful basis correct, cross-reference where you can, and link to other documentation. Don't try and put it all in one point, because you'll be chasing your tail a little bit, So, but yes, please, always understand and document your data flows, and where your data is and who's got responsibility for it, and so on.
Great, good advice, Steve. The next question is, I think, for you, Phil, potentially. As Brexit approaches, the EU-UK representative needs to be recorded. So who should record this information? Should it be the controller, the processor, or both?
So just on this point, just to kind of explain to everybody, we have a rule at the moment in the GDPR that essentially says that if you're a non-EU organisation, you need to appoint a representative in the EU, and the idea is that representative is kind of like a contact point for local data protection authorities who have an issue with you and don't want to deal with you outside of the EU. They can have a local representative that they can engage with, and what So at the moment that requirement exists. Now, when the UK ceases to be a member of the EU, of course, if you're a UK organisation, you may then technically, because you're no longer part of the EU, if you're processing EU data, you may need to appoint a representative in the EU. And conversely, if you're a European organisation that is collecting data about people in the UK, you may actually need to appoint a UK representative, because the UK law basically mirrors the GDPR. So you get this slightly perverse situation where UK orgs may need to appoint representatives in the EU, and representatives in the EU, organisations in the EU may need to appoint representatives in the UK. But basically, if you do have a representative, then yes, you're required to keep that information in your Article 30 record. And actually that requirement applies regardless of whether you are a controller or a processor. So just make sure you document that accordingly. And just to the earlier conversation that was being had about the different versions of the Article 30 templates that exist, to my knowledge, I think there's 3 at the moment. There's the UK ITO, there is the CNILS one, and there is the French Data Protection Authority, and there's one by the Belgian DPA. I would wholly ignore the one by the Belgians. It's terrible. The UK ITO one, I think, as Steve said, it's pretty long. I find it. It's a little bit too comprehensive for my liking, but I do know there are people who are big fans of it. Personally, I favour the CNIL, so if you get that and translate it, that would be the one I would work with.
Good advice.
Great advice. Thank you so much. At what level should the processing activities be itemized for regulatory compliance? For example, is recruitment sufficient, or would you need to document processing activities individually relating to shortlisting interview candidates, post-interview assessment of candidates, contacting unsuccessful candidates, or seeking references for successful candidates, etc.?
Thanks, Vicky. I think that comes back to the point that Steve mentioned earlier, to kind of, be specific but equally not so detailed about what you're going into. So I think those examples there, you could kind of almost separate them into 2, like almost like recruitment from kind of almost like prior to kind of a successful application, and then almost like you can break it up into 2, because I think there's certain data that will be collected at the pre-recruitment stages, when you're kind of looking at CVs and things, and then there will be information post a successful application. So I think if there's almost kind of a divide that you can do with that, but then keep it equally, for recruitment purposes or whatever, rather than going into so much detail, because otherwise you'll be chasing your tail, as Steve said. There's so much information that you can add. You do think what's actually practical. You need to think about time concerns here and everything, really. So I think just keeping it as informative as possible, but not to the point where you're over-engineering it.
Yeah, absolutely. That's sound advice. Thank you, Sana. And Phil, this one for you. I think you probably touched on it a bit in the last question, but I think we can address it anyway. Is the controller responsible for ensuring processors implement their own RoPA, or is this down to the processor alone?
Excuse me. It's primarily the processor's responsibility. Under the GDPR, the processor has a direct responsibility to create records of processing itself, in the same way that the controller has a responsibility under the GDPR to create its records of processing. Having said that, there is a general sort of due diligence obligation on controllers when they are engaging processors, to make sure that they are engaging a processor that can comply with law. So they're not directly responsible for ensuring their process has created an Article 30 record, but I think it would be reasonable to expect that when a controller is engaging a processor, it may be asked some questions about the processor's compliance, and one of those questions may well be, are you maintaining Article 30 records?
Yeah, absolutely. That makes sense, Phil, doesn't it? It's just sort of general kind of supplier or third-party risk management process. Phil, I'm afraid this one actually is probably back to you again, because it came off the back of something that you were talking about earlier. The person says, I'm surprised that an organisation would try to maintain 2 different versions of RoPA, bare bones for Article 30 regulator and a more full version for internal use. In the event of regulatory investigation or litigation, wouldn't the internal version become subject to mandatory disclosure? And how are regulators likely to react to this split records approach when they find out?
Well, I think so. The starting point of that question is, I think internally you don't necessarily need to maintain them as 2 documents. You can have one document. It's just that typically within the kind of document, I imagine that, for example, Sana may maintain, there will be additional columns within it that go above and beyond what is actually required by Article 30. And so that, there may be questions about, is there a risk associated with the processing? Do we need a DPIA? Do we need an LIA? All those kinds of things. Now, as I said, those are not things that are actually strictly required by Article 30 itself, but they are good information governance, they're good information management to kind of maintain and have a central resource you can go to see what's happening. Now, if you are subject to a regulatory investigation, your obligation to the regulator will be to provide the Article 30 record that you are required to maintain as a matter of law. So if you're maintaining, say a big spreadsheet format with additional columns you don't need, there is absolutely nothing wrong with removing those columns and just sending the regulator the subset of columns that it is entitled to have under the GDPR. Now, that's a kind of regulatory investigation. If it were for whatever reason to spill over into litigation, could the wider document be disclosed as part of some kind of litigation disclosure process? I mean, I suppose the answer to that is it's always possible. You can never guarantee that the documents won't be produced in the course of litigation. But I think, one of the things that makes Europe very different, say, to the US, is that we are not primarily a litigation-led culture. If you're a US privacy professional, you live in fear of the next class action that you're going to get. If you're a European privacy professional, most of the enforcement scenarios you will face over time will be regulatory-led. There will be some regulator contacting you and asking you to provide documentation. So I think the reality is that if you maintain this and you just strip it back to what are you actually required to provide a regulator in any given circumstance, a regulator would generally be happy with that. I've never had a situation where they haven't been. But B, they can't actually require you to produce more information than you are required to maintain as a matter of law anyway. So anything you do maintain above and beyond that is really just good practice on your part.
Excellent, thanks Phil, that's really nicely summarised. Sana, one for you here. How often should a RoPA be reviewed and updated? Is quarterly sufficient?
Well, that's a really interesting question there because I think from my perspective, and obviously, legally as well, your RoPA must always be up to date. So I think that's something that every business needs to be obviously mindful of. And obviously really think about how they're going to practically do that. Is it, I can see somebody's made a comment here about kind of, potentially even doing it yearly being difficult. And I think you do need to weigh these things up. But I think it ties right back down to accountability. I think, if you are an organisation that has a data protection office that can support your business, that can, really, help and keep on top of this and give those reminders to each business function, or however you might have divided up your RoPA, I think that's obviously something that they can support you with. But if you are a smaller organisation with, say, 1 or 2 professionals helping in the area of data protection, I think you need to kind of almost push this back to the business and make them mindful and aware that this is something that is everybody's responsibility, and that can tie into sort of training and awareness pieces and making sure that the people who are almost kind of assigned with the role of keeping on top of the RoPA are aware of that. But yeah, ultimately we do need to be on top of it and make sure it's up to date all the time, and each business needs to consider how they want to do that realistically.
Yeah, absolutely, makes sense. Thanks, Sana. Phil, I think you wanted to chip in.
Yes, just very briefly. I think that is one of the biggest challenges that we see with clients, is that they tend to view the RoPA as being a once created, it's all over exercise. And the practical challenges of maintaining it are very difficult. But one of the things I have seen particularly tech clients do is that when they, if they're initiating some new kind of product launch or product feature, typically there will be a product initiation process as part of that. And as part of that kind of, that new initiation process, normally there's some information that you can actually build into that process, some information gathering about, what new data is going to be collected, how is it going to be used, and you can actually require the business to supply that information and kind of feed it back to the owner of the records, who can then drop it into the Article 30 records. So rather than needing some kind of formal quarterly or half-yearly check as to whether the record's still up to date, you can get this information drip-fed through to you as new products are being produced by the organisation.
Oh, thank you, Phil. Thanks to all three of you. I think, it's a difficult subject. It's clearly really, really comprehensive, and it's been difficult, and I'm sure potentially continues to be so for many organisations. And I think the advice you've given is really pragmatic and is going to be really helpful for our audience. So before we round off, I'd like to ask each of you actually if you have any sort of final tips or practical thoughts. So thinking about maybe the top 3 things that people grappling with this need to consider first out of all the advice that you've given today. Sana, do you want to start with that, please?
Sure, of course. I'm going to keep it quite basic because, as you said, it is a very comprehensive area, and I think going away with some just very basic tips that can help, I think would be quite helpful for everybody. So firstly, I think, kind of your RoPA with your data mapping and your inventory, all of these things coming together, I think really form good housekeeping as well, generally. I think if you get nervous about the kind of course, there is a legal obligation to do so, but I think it really ties into each organisation being aware of just the basics, the data protection principles, kind of where you've got staff turnover, people coming into roles, leaving, all sorts going on with, the complexities of each business. I think a RoPA is a really good base for that. So if that is one thing that you can stay on top of in the area of data protection in your business, I think you're winning kind of thing if you really can stay on top of that. And also how you might divide your RoPA as well. I think some organisations have just kind of one document which is, has everything set out in it, whereas I've seen some instances where it is broken down by business function, and that business function is responsible for their area of that RoPA. So that's kind of, I think, my key tip really, to kind of separate it out and make it relevant and personal for your business, and just treat it as your housekeeping. I think it's really, really important to focus on that.
Excellent, thank you, Sana. Phil, any advice from you?
Yeah, I think we've largely covered the advice I would probably give. I think the ownership point is really important. Work out whether you're going to centralize ownership of the RoPA or whether you're going to devolve sort of ownership of individual RoPA to particular functions. They maintain function-specific RoPA. Typically, we see a lot of internal fighting over who wants to be landed with the job of maintaining the RoPA. I think Steve's point earlier about make it granular enough, but not too granular. Any processing activity can be further broken down into sub processing activities. You need to just have sensible categorizations that reflect what you're doing without going to the nth degree of detail. Otherwise, you will create a document that's just impossible to maintain. And then thirdly, I think would be my one, which is, make sure that what you maintain internally is not necessarily the same thing as what you disclose externally. Anything you disclose externally should be limited to just what is required as a matter of law in the GDPR.
Excellent, Phil. It really is about keeping it simple and keeping it relevant for the organisation. So, Steve, over to you. Any advice from you to round us off and take us to the next week?
It's been a great show, and I was looking forward to the RoPA one because I think, Phil, I could almost see the rolling of eyes across millions of people when we started advertising RoPA. It's like, it's not the most queuing around the block, but it is actually quite complex, and a lot of people struggle with it. And therefore, my advice always is if you can do a lot of the data discovery through automation, then you're gonna using a whole variety of tools. You're going to make your life slightly easier. In other words, know where your data is and what it's doing. The other thing is, which I found to be really useful, is, and it goes to this sort of decentralized point that Phil mentioned again, and the sort of housekeeping piece that Sana was saying about. I think it's really important to create the how to complete a RoPA, and that's something that we've spent a lot of time, Vic, building for our clients, is that guidance in a playbook or in a video, so that they do understand that, because to chuck it over the fence to someone and just say complete this, and I have actually been into organizations where they've done that and it's failed miserably across different markets around the world. They've just asked them to complete it. So really think about how it lands, and then I suppose, as I would do every week, I will always promote it's about culture, and you've got to help people. You can lead the horse to water, but you know, you can't always get the horse to drink it. So you've got to help them. You've got to make them understand why it's so important to understand your lawful basis and why this document is such a key document. And that's about training, awareness, changing behaviours, and you know, which is obviously privacy culture.
Absolutely, always comes back to training and awareness. So what have we got going on next week now that we've moved out of the 12 domains?
Do you know what? I'm really excited about next week's show because well, two shows. We're going to stop for August. So the last two shows we these are extra bonus. So next week we've done the unusual step of having two lawyers from one firm talk to us about vicarious liability. Now, we all, as professionals, have read about the Morrison's case, but I've always struggled with this one because I'm not a lawyer. I didn't really understand there's a situation where one party is partly responsible for unlawful actions of a third party. So I spoke to Helen Devonport and Rosia de la Cruz from Gowlings, whom were part of the defence team for Morrison's. So they were first-hand in the firing line, trying to get the decision overturned, and that was such a instrumental piece. We all held our breath collectively, waiting for the outcome of that case. And thankfully it got overturned. So that's next week. So we've got two guests to talk to us about vicarious liability, which is a mouthful after you've had a bottle of Prosecco. And then finally, the grand finale, which I'm really excited to announce to our listeners, is we have the data commissioner for Guernsey and Jersey on the show for a really good fireside chat. Emma Martins has kindly agreed to appear on the last show. That's Friday the 24th, before we come back in September. And she's going to be talking about all sorts of things. Now, I asked her about Schrems too, and I asked her about all the kind of topical things. And she said, look, I've got to be careful about Brexit, and I've got to be careful about what I say on these matters. But she does have some interesting thoughts on profiling and the use of personal data in those contexts. And of course, Guernsey and Jersey, as we know, has one of the, offshore financial capitals, if you like. Lots of organisations, wealth management, use it for tax reasons, I'm sure. But so, yeah, I'm delighted to say on the 24th, we have Emma Martins, the Commissioner. And next week, we have vicarious liability with Helen Devonport and Rosia de la Cruz. So, yeah, tune in. Should be good.
Excellent. I'm looking forward to that. Content rich couple of weeks coming up then. Great. So it's time to say goodbye, unfortunately. So thank you so much, Sana, for contributing and being with us today. Fantastic advice. I'm sure our audience really benefited. And thank you to Phil also for your wisdom. Brilliant. Yeah, as ever, fantastic show. I hope everyone's enjoyed it, got lots out of it, and we'll see you again same time next week.